panel of judges with us tonight. Thank you so much for giving of your time on a Saturday evening. These students have worked hard and they're very excited, and we're excited to have you here. I'd like to introduce our panel starting from my left. First, we have Dennis Schultz. Dennis has lived and worked in many different locations around the world, including St. Croix, the U.S. Virgin Islands, and Syria. He holds a bachelor's degree in agriculture economics from Oklahoma State University. Mr. Schultz is currently the manager for material management for Wood Group Mustang. He enjoys spending time with his wife, Renee, and their 3 children, golf not included. Thank you.
Even if you haven't seen the movie, there's still a 99% chance that you are familiar with the phrase, "you can't handle the truth," which comes from the film. Now, in the scene where those immortal lines were delivered, Tom Cruise, who plays a young Navy attorney, is trying to get to the bottom of why his commanding officer ordered an illegal action, resulting in a sailor's death. Tom Cruise was trying to determine the action behind, the reasoning behind the action. This is something that we see in everyday life. We try to prove that somebody did something wrong and that they knew that their action was in fact illegal. If you were to somehow take my wallet or purse after the round, I would have to prove that you did it on purpose. Maybe it looked like yours, or you grabbed it with some of your other things. Either way, I would need to prove that it was in fact intentional. Justice Holmes famously illustrated the concept of intent when he said, quote, "Even a dog knows the difference between being stumbled over and being kicked." When sentencing someone to decades of jail time, the requirement to prove intent could be the difference between you spending 2 years in solitary confinement or being justly acquitted. Today, I stand emphatically and unequivocally resolved that the United States federal court system ought to be significantly reformed. Now, before we go any further, I would like to frame the debate with one definition: mens rea. My first definition is mens rea. M-E-N-S-R-E-A. Now, this is a Latin term meaning guilty mind. According to the Black's Law Dictionary, in the criminal justice system, the knowledge of the act should be just as important as the action itself when we decide guilt or innocence. When a criminal is on trial, the prosecutor must prove 2 things. First, that a crime was in fact committed, and secondly, that the individual knew that their action was illegal when they committed that crime. Sadly, this burden that the prosecutor must uphold is being weakened by acts of Congress, and we will examine this further later on in the speech. Further definitions can be presented upon the negative teen's request. Now let's move on to the facts of the current system. You can tag my first fact as criminal intent is key. Criminal intent is key. This is from the Black's Law Dictionary. Quote, "Criminal intent is a necessary component of a crime and involves a conscious decision on the part of one party to injure or deprive another. Mens rea, the basis for the establishment of guilt in a criminal case." Now, the negative teen may say, you can't get inside someone's mind to know what they were thinking whenever they committed a crime. And my partner and I completely agree. Our plan does not require mind reading of any kind. It's simply a standard used within the courtroom based upon certain actions a guilty party takes. Now let's move on to my second fact. You can tag this as innocent until proven guilty. Innocent until proven guilty. This is from the Heritage Foundation. Quote, "The principle of fair notice, which has been a cornerstone of our criminal justice system since the nation's founding, is embodied in the requirement that, with rare exceptions, the government must prove that the defendant acted with a guilty mind before subjecting him to criminal punishment." Now, the importance of this standard cannot be emphasized strongly enough. Looking to the tax code, which is alone over 73,000 pages long, we can see that it would be impossible for one individual to read, let alone understand a fraction of what is in this code. In fact, just this last year, according to the Heritage Foundation, there are nearly 5,000 criminal statutes and over 300,000 criminal regulatory offenses. Now let's move on to my harm that my partner and I seek to solve. Harm 1, vast lack of intent. Vast lack of intent. This is from a study from the Heritage Foundation and the National Association of Defense Lawyers. Quote, "This study revealed that offenses with inadequate mens rea requirements at all stages of the legislative process, over 57% of these offenses introduced, and 64% of those enacted into law contain inadequate mens rea requirements, putting the innocent at risk of criminal punishment. Compounding the problem, the study also found consistently poor legislative drafting. So essentially, this is referring to the most comprehensive study currently available. We see what can only be described as a smoking gun, and this demonstrates a detrimental flaw in the current system. This leads to two extremely vital implications. A, due process violated. Due process violated. Since we have established that the component of criminal intent is vital in any trial where we deprive someone of their life, liberty, or property, the lack of intent in nonviolent trials is, in fact, a violation of your constitutional right to due process. B, injustice justified. You can tag my next point as injustice justified. Now, the negative team will likely ask for a specific number of people affected by the lack of intent in the current system. So I would like to preempt that argument now. My partner and I are not solving for the specific number of individuals harmed by this. We are solving for the vast lack of intent that currently exists within statute, which is an inherent flaw in our system. Now let's move on to the plan that my partner and I advocate. Mandate 1, enact default mens rea. Enact default mens rea. This simply means that a guilty mind requirement is to be present when an inadequate standard exists within statute. Essentially, the prosecution must prove that the defense acted with a guilty mind as defined within current statutes, and this ensures that no one is wrongfully convicted. Mandate 2. In case of unclear legislation, benefit of the doubt may go to the defendant. Basically, whenever Congress is not clear, the judge can grant leniency. Now, this plan applies only to establishment of guilt or innocence in a nonviolent criminal case. It does not apply to the punishment or sentencing phase of a trial. Now let's move on to the advantages of our case. Advantage 1, due process upheld. Due process upheld. This is from the Heritage Foundation. Quote, without reforms like those recommended in this report, innocent individuals are at risk of unjust conviction under an uncountable number of offenses. We have over half of law that lack a mens rea requirement, and they are continuing to stay on the books year after year. As Jean-Jacques Rousseau, who had a unique and profound influence upon our Constitution, stated in his famous social contract, man is born free, but he is everywhere in chains. Let us tear apart the chains that bind us and restore the rights that free us. Thank you so much. And I now stand open for cross-examination.
Congratulations on making it to finals.
Thank you, you too.
Thank you. I just have a couple of questions. First of all, can I have a copy of your 1AC?
Yes, ma'am, I have it back at the table. Is it all right if my partner passes that to the
Sure,
board?
that's fine. Now moving on to, does the affirmative team have the burden to uphold the burden of proof?
I do believe that we need to show a problem in the current system and that we do solve for this problem.
All right, and that you create a significant advantage on the system, correct?
Absolutely, yes, ma'am.
All right, so how many cases, how many trials are affected by inadequate mens rea requirements?
Well, currently within statute, 67% of laws in nonviolent crimes do not have a mens rea requirement.
All right, would you agree that that applies to the laws but not necessarily the cases that come to court?
Because it's not within statute, the judges do not have to provide a mens rea requirement within current statute.
So generally, how many cases does that affect? How many cases with inadequate mens rea requirements go to trial?
I did not bring up numbers in my speech, however, I can respond to that in my next speech.
We'd love to see that. Has anything ever been done to fix these inadequate mens rea requirements?
No, that is why the affirmative team is presenting the plan.
All right, are you aware of a 2015 act to enact mens rea requirements that has recently been put into Congress?
It actually has not been passed, but if you would like to bring up a study that states that it has been enacted into law, then I would.
But would you agree that it's currently sitting in Congress?
Congress has not passed it, therefore this plan is still very relevant because we see that there is no change in the current system.
All right. Are there different criteria for determining mens rea?
The current statutes within status quo in 33% is the burden to prove intent within criminal cases.
And how do you prove intent? Are there different criteria for proving that?
There are, but we're using the intent and the standard that is currently within the status quo.
Right, so you're using what the status quo already uses.
Yes, in 33% of cases.
All right, thank you. No further questions.
Yes.
Please start.
In team policy debate, the affirmative team must uphold 3 key burdens. Please write these down because we'll be showing you throughout today's debate round that because they do not uphold these burdens, you cannot vote affirmative because they failed their burden to prove these things. The first burden I'd like you to write down is that there must be a significant problem. Essentially, to do this, the affirmative team must prove that there is a problem with the current system and that their plan solves for this problem. I'll be showing you in my speech specifically how they have failed this burden. The next burden that the affirmative team must prove, please write down as solve the problem. Solve the problem. They must present a problem and also solve it. This is what we need to justify an affirmative ballot. They must solve the problem they present. Please write down the third burden as significant advantage. Significant advantage. Not only must there be a problem and they solve it, but there has to be some advantage in it, some reason to vote affirmative at the end of today's debate round. So let's get into the actual refutation. Essentially, the first key point I'm going to be making is showing you how there is no problem in the current system, so there is no need for the affirmative team's plan. Please write down my first point as mens rea currently applied. Mens rea currently applied. Now, what we're going to be seeing by evidence is that the Supreme Court has actually said that the fact that mens rea is not written into these laws does not mean that it is not applied in the actual cases. This piece of evidence comes from Mark Melling quoting the Department of Justice statement in 2015, and he says, quote, "The Supreme Court has made clear that there is no need for a default mens rea. As the court stated in Illinois versus United States, quote, the fact that the statute does not specify any required mental state, however, does not mean that none exist. We have repeatedly held that mere omission from a criminal enactment of any mention of criminal intent should not be read as dispensing with it," end quote. The impact of this piece of evidence is that even though the mens rea requirements are not written into the bills, and that's what the affirmative team has presented us, they are actually applied when these cases are brought into court. Now, the impact of this is that there'll be no change. Please write this down as no change. Essentially, what we see here is that mens rea is actually being applied in our courts because the Supreme Court has said it should not be inferred that there should be no mind requirement when it's not written into the bills. Instead, it should be taken as if there is one. What we see here is that since the Supreme Court writes precedents for all the lower courts must obey what the Supreme Court has mandated. What we see here is that the lower courts must follow the Supreme Court's decree that mens rea is actually enacted when they're looking at the cases. The fact that it's not in the statutes does not mean that it's not, in fact, in the cases. So you see here there's absolutely no change because what the affirmative team is advocating for, changing these mens rea requirements to hopefully impact cases, is already happening. The cases already have mens rea requirements. The impact of all this is there is absolutely no problem. Please write this down as no problem. Since mens rea is in the current system, the affirmative team is not showing us any problem because we currently have mens rea, the thing that they're advocating for. This brings me to my next point. In their example in their 1AC, they talked about the tax code. Well, an interesting thing is that mens rea is actually inferred into the tax code. Please write this down as mens rea in tax code. Mens rea in tax code. This is from Marking Winnings from 1993, and he says, quote, "In United States versus Cheek, the Supreme Court made it clear that the traditional maxim, ignorance of the law is no defense, does not apply to tax crimes. A taxpayer may behave outrageously, even to the point of not paying any taxes without criminal penalty, as long as the taxpayer subjectively believes he is obeying the law. The message to the would-be tax evader is clear. If you don't know anything about taxes, you can't be guilty of crime," end quote. What we see here is that mens rea requirements are actually inferred into the tax code. This piece of evidence is saying is that if you truly did not know you were breaking a law, it cannot be brought against you in tax law court. So what we see here is that mens rea is actually being applied to the very example they gave that why we need their plan. We currently see it is in the current system as the tax code just gives us one more example of. Now, the next point I'd like to talk about is how we're dealing with laws, not cases. laws, not cases. The Affirm team has presented numbers in their 1AC talking about how many laws do not have mens rea requirements in them. But the problem is this is not cases. We have no numbers in today's round on the cases that mens rea requirements are not inferred into. Essentially, the Affirm team must prove a problem. And the problem that they're essentially trying to solve is that mens rea is not applied in our court system. But they presented no numbers on this. We have seen that there are cases that lack mens rea requirements, but as we have seen, the Supreme Court mandated that those should be inferred into any laws that lack mens rea requirements. And so we see that there is truly no problem. That the problem lies in the laws, not the cases. And that there is no true problem in our court system because we deal with the cases and it is inferred. This leads me to my next point about no numbers, no problem. Now, the Affirm team has not presented numbers on how many cases or people are impacted by mens rea requirements not being presented. And the reason for this is because mens rea requirements are actually implemented in the current system. As we have seen, the Supreme Court has ruled on this. What we see here is truly, there is no problem, they have proven no problem. Mens rea requirements actually are inferred and they are protecting citizens in our current system. Now, this leads me also to an interesting point. Please write this down as under-criminalization. Under-criminalization. This piece of evidence, these actually two pieces of evidence, are going to tell us how mens rea requirements are actually currently being applied, and second of all, how there's actually an under-criminalization due to them. Now, the Affirm team would like to have you believe that because mens rea requirements are not in place, then people are being convicted of crimes that they actually not should be convicted for. This would be over-criminalization. But as we will see, the problem in the current system is actually under-criminalization. Now, please write this down as white-collar crime unique. White-collar crime unique. This is from Zach Carter from 2015, and he says, quote, "Large, complex corporations can diffuse responsibility for illegal activity, which can make it difficult for prosecutors to prove that executives knowingly and willfully violated the law." End quote. We see here is that the way that our corporations are set up, it's very hard to prove that the head guy or the CEO actually ordered an illegal issue. Now, the impact of this is if we have to prove mens rea, if we have to prove that there was a guilty mind, if we have to prove that the head guy actually ordered this, then we actually will not be able to convict them most of the time. And that's what my next piece of evidence states. This is from Professor Raina Steinzer in 2015. And she says, quote, "Despite the isolated anecdotes advanced by the Heritage Foundation and its allies, the simple truth is that federal and state prosecutors are overly hesitant to bring white-collar cases. Whether these prosecutors are afraid of losing, worried about matching wits with big law firms, or lack the political will to proceed, the end result is the same. People die for preventable reasons every day in America, and the vast majority of corporate managers responsible for such episodes escape even a hint of criminal charges." End quote. So what we've seen here is when we look at mens rea requirements in our current white crime status in the United States, we see that because we have mens rea requirements, and it's very difficult to prove this guilty mind when we have a corporation where it's very hard to track where the order came from, we actually have a problem of under-criminalization, not over-criminalization. So in the end, we have seen that the Supreme Court has ruled that mens rea is currently applied to the cases in our court system. There's absolutely no problem. They are making no change because this is the current system. And we have seen this through many examples, first the Supreme Court, talking about the tax code and also white-collar crime. Thank you, and I now stand open for cross-examination.
Hi, Veronica. I have just a few questions for you.
Sure, Laura.
In your first point, you talked about how we need to prove that there is a significant problem. Now, how many statutes need to not have a mens rea requirement before this becomes a significant issue to you and your partner?
Now, the negative team believes that the problem that the Affirm team is presenting is that mens rea requirements are not always required. What you've seen is that while that may be true in the actual text of the law, that is not true with cases. There is actually no problem. Mens rea requirements are actually being inferred into the cases themselves.
All right, so we should leave it up to chance whether or not an innocent individual is put into federal prison or not.
That is not my contention. My contention is simply, if the law does not contain mens rea requirements, the courts are actually interpreting them to be so. So even if a law did not include mens rea requirements, that does not open up the possibility for them to be wrongly convicted because the courts are actually inferring this.
So you talked a little bit about the Supreme Court. Now, in the case of, I think it was Illinois versus the state, what exactly was this case pertaining to?
I can read you the piece of evidence.
It says state in the piece of evidence what the case was pertaining to.
This did not specifically state what the case pertained to, but I'd say as the court stated in this decision.
Okay, you do agree that after Supreme Court decisions, other courts, it's based off of precedent, so unless a case is exactly almost the same as the one that was heard in the Supreme Court, then they don't necessarily have to follow that, correct?
I believe that precedence can be applied different ways. Now, very specific cases, the precedence is obviously very specific, but as it said, this is talking in general terms about when there's not a mens rea requirement written into. It does not mean that none exists in very broad terms.
So that means that courts do not need to abide by a mens rea requirement because it's used every now and then.
That was not my contention. My contention was that, as the evidence states, the fact that the statute does not specify any required mental state, however, does not mean that none exists.
Okay, you do agree that the judicial system within that, their job is to interpret the laws thereof, correct?
The judicial system job is to interpret the laws, correct.
Okay, so if mens rea is not in law, then it's up to the judge's discretion, right?
That is not correct because, as the Supreme Court has ruled, they need to infer that one exists, and the Supreme Court sets precedents for all the lower courts, and so the lower courts must follow what the Supreme Court has said.
Okay, but unless in the lower courts the case is like the Supreme Court, then that precedence does not exist, correct?
I do not agree with that. The reason being that this is actually a very broad terms that the Supreme Court is saying it. It was not saying the specific issue, but rather when the statute does not specify any required mental state, one doesn't exist. It's talking about the fact that the statute doesn't exist.
All right, and you agree that only in 33% of current statutes is there a mens rea requirement?
If you present evidence or when I see them, sure.
Okay, all right, thank you. It looks like we're out of time.
In the second affirmative constructive of today's debate round, I'll be walking down the flow of what the first negative speaker just shared with you, and showing why the affirmative team, first of all, meets its burden that they've placed on us today that we completely agree with. Secondly, how it not only does that, it also exceeds the burden they placed upon us and provides an advantage above the status quo, with the experts overwhelmingly siding with the affirmative team and saying that this mens rea standard does need to be proven. Before I get into that, though, I'd like to start with a story. We all like stories. So I'm going to read a personal example of where the mens rea lack affected someone in the status quo. This is from Dr. John S. Baker, Georgetown Law School, Professor Emeritus, LSU Law School. Even more threatening to the innocent are the many federal crimes which lack mens rea. In the Wall Street Journal, they chronicled the story of Wade Martin, a native Alaskan fisherman who sold 10 sea otters to another person he thought was also native Alaskan. Mr. Martin was thus surprised to find himself arrested for violating the Marine Mammal Protection Act, which criminalizes the sale of certain species to those who are not native Alaskan. Even though Mr. Martin believed the buyer to be native Alaskan, that important fact did not matter. The federal prosecutor would not have to prove that Mr. Martin knew the buyer to be other than native Alaskan. So, on the advice of his attorney, Mr. Martin pleaded guilty and received 2 years on probation with a $1,000 fine and still lives with the stigma of a criminal conviction. Mr. Martin's misfortune was not attributable to some exceptional federal criminal statute. Statutes with weak non-existent mens rea requirements range from criminal violations of the endangered species to the unauthorized use of a 4-H club logo. Federal criminal statutes with weak or non-existent mens rea requirements undermine the rationale for criminalizing conduct. And what this evidence right here is saying in the testimony before a congressional committee is that the current system completely lacks this mens rea and needs to be instituted. This does in fact affect people in the status quo. And the 3 burdens that the negative team gave us today was that we need to prove a significant problem, we need to solve that problem, and lastly, we need to give you a significant advantage. We absolutely agree, and that's what we'll be doing throughout the rest of the speech and throughout the rest of the round. First of all, I talked about how mens rea was currently applied. I have 2 responses. Only applies to 1 case. Please write down only applies to 1 case. Now, in cross-examination, my partner alluded to this, but if you look at the evidence that the negative team read, it was talking about a Supreme Court case, Alonis versus the United States, that they were unable to tell us the details of. And the way the precedence works in the Supreme Court, if they decide a certain idea or they just make precedent in 1 case, it only applies to that specific area of law. It doesn't then apply to nonviolent crime or to every single area and instance where this would come up. We don't even have any idea if the evidence that they read in this case was violent or nonviolent crime. We have no idea that this deals with the affirmative team. So until such a time as they're able to provide us with that evidence, then that does not apply to our case. My second definition, though, is Supreme Court actually agrees with the affirmative team. Please write down the Supreme Court agrees with the affirmative team. Now, I believe what the negative team was alluding to was actually the judicial rule of lenity, which actually isn't a rule at all. It's a judicial practice that is sometimes used, where the judge will extend leniency if he doesn't feel Congress has been clear enough. However, what my partner and I seek to do today is codify this into law, making rights and upholding mens rea for all American citizens. And here's what the evidence says. Quote, the Supreme Court noted in 2008 the judicial rule of lenity exists because, quote, no citizen should be held accountable to a statute whose commands are uncertain or subjected to punishment that is not clearly prescribed. Now, what this is saying right here is exactly what the affirmative team is advocating for today, that no American citizen should be punished without his constitutional right of due process. That's what we enact, and that's what we solve with a plan underneath an affirmative ballot. And next, talked about how there would be no change and no problem. Once again, I have two responses. My first, Attorney General says that mens rea is vital, and I abbreviated it. AG says MR is vital, just to help you write that down quicker. And here's what he says. Former Larry D. Thompson, former Deputy Attorney General. He says there are currently an estimated 4,500 federal statutory crimes, as well as thousands of regulations which carry criminal penalties, and thus unknowable by any one person. The resulting ambiguity in the criminal justice system threatens to undermine its own integrity. This ambiguity also causes business people to hesitate to take significant steps without first lining up time-consuming and expensive legal and expert review, advice, and opinions, creating a huge drain on productivity and innovation. So what we see from this piece of evidence right here is that the experts once again overwhelmingly side with the affirmative team. The Supreme Court and the former Attorney General highlighting the need and the necessity for a mens rea requirement in the status quo, one that is codified into law, not one that is just sometimes extended and sometimes not. My second response is wrongful conviction. Wrongful conviction. Now, far from this being an isolated problem, we can bring up many examples and stories. Another one is Mr. George Norris, an elderly retiree who was jailed for 2 years in solitary confinement for selling orchids that he did not know were illegal. Now, this, to me, is an abuse of the justice system. We need to be convicting people that are actually guilty, not ones that are just making honest mistakes. And that's what an affirmative ballot would solve for today. Next, I talked about how mens rea is in the tax code. My response, I have two of them once again. My first, 33% only. My response to their mens rea and tax code argument, 33% only. Now, my partner read this in her 1AC. We do agree that mens rea does exist in the status quo in some cases. We're not contending that at all. We're just saying that it doesn't exist in the majority of crimes, which is our harm that we seek to solve. My second response is this actually supports the affirmative team. This supports the affirmative team. This goes to show you that this is an effective standard, and it's one that's used in the status quo. And the negative team has taken the position that this is an impossible standard. It's very difficult to enforce. But when we look at the status quo, we see that it's working very well. In fact, the negative team themselves read an argument and an article that upholds this fact, that mens rea is an effective standard, and that's being used in certain areas of law. My partner and I seek to apply that same standard to areas of crime, nonviolent crime, that do not currently have it. That is all our plan does today. Next, I talked about how there would be laws, not cases. My response is Congress is our actor. Congress is our actor. Now, without getting too much into debate policy or debate theory, which I know no one wants to talk about, I'd just like to quickly point out that the resolution that we're debating today is that we should reform the federal courts. It nowhere, anywhere themes an actor or says who we have to use in order to enact that reform. Now, if you recall back to my partner's 1AC, she named Congress as one of our specific actors. So if the negative team would like to argue the details of this, we've already addressed this, and we've already named Congress as our actor to enact this reform in the status quo. My second response, 67% of cases detrimental. 67% of cases detrimental. And that's exactly what I mean by that. The negative team is taking the position today that unless we show you an exact number of people harmed, which is impossible, and I'll get to that in a minute, we can see that every case that goes through the criminal justice system that falls underneath this lack is in fact a violation of due process and an injustice in the current system. Now, that ties directly into their next argument. This is no numbers, no problem. My first response is gave examples. I already gave examples. I talked about the two stories, and we can definitely read more if the negative team would like. But my second response is impossible burden. This is the more important response. Once again, impossible burden. You know, what the negative team is taking here, to use an analogy, would be someone internally bleeding and they're coughing up blood, and they say, well, I don't see anything, I don't see a cut on you, I don't see any injury, so we're not going to take you to the doctor until you die. So that's essentially what the negative team has taken, the stance they've taken in today's debate. Since they don't see anything on the outside, we're not going to solve the problem. We're going to wait until it gets really, really bad before we seek to solve anything. Now, this is operating in a reactive mode. What the affirmative team seeks to do is solve this before the harm occurs. Next, I talked about under-criminalization. My response is responsible justice. Responsible justice. This means that the punishment should fit the crime. If you make an honest mistake, you may still have to face a penalty, but it shouldn't be as bad as someone who did this willfully. We can look at the example of murder. The mens rea or intent requirement is the difference between murder and manslaughter. Someone who dropped a gun that went off and killed someone doesn't deserve the death penalty. And that's the difference between those two. That's one that we can all, violent crime albeit, but that's one example that we can use to highlight the importance of the standard. The last argument was talking about white-collar crime unique. My response, white-collar crime needs due process as well. White-collar crime needs due process as well. Just because it's a different type of crime does not mean that they deserve a less amounts of constitutional rights. So it's for these reasons that I urge an affirmative ballot.
All right, everyone ready? Let's begin. First of all, congratulations, James, making it to final.
Same to you, Veronica.
All right, just a few questions.
Sure.
So did you present evidence in your speech on the total number of cases or people wrongfully convicted, or is it just specific examples here and there?
I gave you specific examples and also talked about how any case that arises underneath that 67% lack is an unjust case and a violation of due process.
So is it your opinion that because it's not written to the statute, that of course it's not applied by the courts?
No, it wasn't my intention at all. Now, if I can quickly address this, I talked about the rule of leniency, which is a judicial practice. Justices sometimes choose to extend it, and sometimes they don't. Now, it's my partner and I's contention that we shouldn't leave this to chance, but that we should give due process to every American citizen.
All right, so you brought the rule of leniency. Now, was the date on that 2008?
That was the date the Supreme Court decision was made. That's correct.
Great, all right. And so what specifically makes you think that this rule of leniency should be applied to all cases, whereas the precedents that the Supreme Court cited in the case that we brought up should not be applied to all cases?
Well, the Supreme Court specifically was talking there about the rule of leniency. Your Supreme Court case was talking about a specific one, was talking about one specific case, which you can't apply then to the entire nonviolent criminal area. The rule of leniency exists for every crime.
Great. Could I please see your piece of evidence on that rule of leniency?
Absolutely. That would be, there you go.
Okay, great. And so now let's talk about reforming laws and whatnot.
Sure.
So you would agree that your mandate is to reform laws, correct?
That's correct.
All right. And do you believe that you're also reforming cases and outcomes?
I would agree that I'm giving due process to every American citizen through the mens rea requirement. Now, whatever the details of that are will be up to the enforcement agency.
All right. And so it's your contention that Americans are not currently getting due process in the courts?
It's not just my contention, that's what the experts say, the Attorney General, and our evidence and empirics from the Heritage Foundation.
All right. You would agree that those pieces of evidence state the number of laws do not have mens rea requirements, not that they're not actually being applied to courts?
The evidence states that the lack of mens rea requirements is a violation of the Constitution.
All right. And could I please see the piece of evidence that you're talking about states that it could be a violation?
Absolutely. There you are.
All right. And specifically where in this piece?
Oh, I'm sorry, that's not the one I read. I apologize for that. It would be this one right here, talking about how the erosion of mens rea requirement, seemingly anorexical, should give us the most pause, the erosion of mens rea.
Oh, great. Thank you. No further questions.
Thanks, Veronica.
All right, are all my judges ready? Let's begin. In this second negative constructive, I'm going to be bringing up new arguments and really building the negative side of this case, while my partner will respond to the second affirmative constructive in her next speech. So before I begin with my arguments, I want to reiterate the three burdens that the affirmative team must uphold. They must prove that there is a significant problem in the current system, or we do not have any reason to pass their plan. Further, they have to prove beyond a shadow of a doubt, that they solve for this problem completely. And finally, that they have significant advantages over the status quo. So let's get into this debate. My first point you can tag as bill in Congress. Bill in Congress. Now, in 2015, according to govtrack.us, a bill was assigned in the Senate to a congressional committee on November 18, 2015, and they will consider it before possibly sending it on to Congress. But this has been in Congress for several months now, and it hasn't been passed. And the reason it has not been passed is what my partner has already brought up, that there is currently mens rea, a default mens rea, being applied in the current system, and Congress has seen no reason to implement this reform through a bill because the status quo is already working.
Judges ready? Timer and microphone. Hi, Sarah. Congratulations on making it to finals.
Congratulations to you too, James.
All right. So now, according to your evidence, let's talk about the 57% or 67% lack in the bill. Now, do you contest the fact that our Heritage Foundation empirics said that there was a 67% lack of mens rea and nonviolent crime?
We were contesting that this refers to the laws and not necessarily the cases, and
Sure.
therefore we don't have a quantified harm.
So you do agree that there's a 67% lack, though, regardless of whether you think those are cases or laws?
Yes.
Okay, great. Now, you talked about a bill that was being apparently brought up in Congress. Where is that bill right now in Congress? Congress?
Currently, I believe it's still in the subcommittee since Congress has seen no reason to pass it.
Okay, what was the last date that action was taken on that bill?
The evidence I brought up was from November.
Okay, now, what are the mandates of that bill?
I didn't address that in my speech, but the synopsis of the bill is a bill to specify the state of mind required for conviction for criminal offenses that lack expressly identified state
Sure,
of
that's
mind.
the caption of the bill?
Yes.
The summary? Okay, so we don't know the specifics, though, or the specific mandates of the bill.
I didn't present that in my speech.
Okay, now, what are the, okay, sorry, I already asked you that. Now, you next talked about John Roberts, and you read a quote from him. What was the context of that article? Was that a majority decision, or was that an interview? What was the context of that?
It was the majority of opinion of the court
Now, in what case?
in the Alonis versus United States case, but he was referring
Okay.
to the broad principle that they've already said applies.
Sure, and what was Alonis versus the United States? What was that case?
That was the case where they had made this clear that they were going to implement the mens rea.
Okay, did Justice Roberts mention the words mens rea, or that should apply to nonviolent crime in his statement?
He said his specific words is that wrongdoing must be conscious in order to be criminal, and that
Sure.
is referring
But
to
he
mens
didn't-
rea.
Gotcha, but he didn't specify whether that was violent or non-violent.
No, he did not.
Okay. Now, next let's talk about you talked about how we had a vague plan, or we're enacting a vague mandates. What exactly would you like specified to make you more comfortable with our plan?
Well, so currently there are different ways that you can require defining criminal intent and proving that that happens, and we haven't seen any specifics on how you're actually going to be doing that.
So I'm just curious what specifically you want us to bring up then.
That's the burden of the affirmative team to prove that they have specific criteria that they must be meet
Sure.
and can be met.
I agree with you. I just wondering what your contention was on that. But let's go ahead and move down. Next, you talked about how there was 4 different levels of mens rea, correct?
I don't think I said 4 different levels. I was just saying there's different types of requirements, and that was the point.
Okay, you would agree there are 4 in the status quo.
Sure.
Okay, great. No further questions. Thank you, sir.
In this first rebuttal to today's debate round, I'll be showing you how there truly is no proven problem that the affirm team has presented you. And because there is no problem, there is no reason to vote affirmative, because your ballot is not going to be solving anything or creating any advantages. So my first major point here, please write down as no proven problem. No proven problem. Now my main point right here is the fact that just because mens rea requirements are not written into the laws does not mean that they are implied unjustly by the courts. So first, my second point is going to be talking about why I do believe the Supreme Court precedents still exist. But first of all, I'm going to show you that the affirm team has not presented a significant problem to us. So even if we do believe that the Supreme Court is not applying mens rea requirements, there should be some numbers talking about the vast number of cases where this is unjust. Instead, let's take a look at what the affirm team has presented in the round. Now, they brought up several examples. They gave one about marine mammals and another about a man selling orchids. Now, examples are not sufficient. Individual examples are not sufficient. We are forming policy here. This is a team policy debate round, and we cannot develop our policy based on limited examples here and there. Rather, we need to know if this is a significant problem in the system, not just an individual example here and there. So let's see if the affirm team has presented any large numbers quantifying this. If this truly is a problem, then there should be a vast number of cases that mens rea requirements are being applied that are unjust, and yet that number has been not presented in this round. Let's take a look at the evidence that the affirm team has presented, and we'll see that they're actually all drawing an assumption. Please write this down, drawing an assumption. Now this piece of evidence talks about how the laws lack mens rea requirements, and that they could be used unjustly. But they never state that they are being used unjustly. We'll start with a piece of evidence from James' speech, and this is the one he told me that talked about how mens rea requirements does put citizens at risk. It says, quote, "Through the years, I've witnessed certain trends within criminal law that are both disturbing and seemingly inexorable. 2 in particular should give us most pause, the erosion of mens rea," and it goes on. But the problem here is that it does not say that mens rea is being unjustly applied. It's just saying that mens rea is not being written into the laws. This does not prove that people are actually being unjustly convicted. This is simply showing you that it's not written into the laws, but not that there is a problem. The next piece of evidence comes from their 1AC, and it says, quote, "Over 57% of the offenses introduced and 64% of those enacted into law contained inadequate mens rea requirements, putting the innocent at risk of criminal punishment," end quote. Now, this evidence is simply saying that it's not written into the laws and that this could put citizens at risk of criminal punishment. It never stated that citizens are currently being unjustly convicted or currently being unjustly put into the courts. None of this evidence is giving us any example of a current problem, and we need that for the affirmative team because they have proven no problem to you. They've simply stated that these laws do not have been enacted, but they have not shown us any examples of injustices. This next piece of evidence actually comes from their 1AC again, and it says, quote, "Without reforms like those recommended in this report, innocent individuals are at risk of unjust convictions under an uncountable number of offenses," end quote. We see as it says citizens are at risk, but not that they are being currently unjustly convicted. There's a big difference here. We essentially see that the affirm team is drawing an assumption just because they could possibly be convicted under these laws. It does not mean that they are currently being convicted under these laws. And the reason for this is my next major point, that mens rea is inferred by the courts. Mens rea is inferred by the courts. Now, the affirmative team gave us a piece of evidence talking about how there is a leniency requirement that the Supreme Court is, and they believe that that's what our evidence is talking about. Now, my first response to this is that leniency does not refute. Leniency does not refute. The fact that the Supreme Court does have a leniency requirement does not refute the evidence that we presented talking about how the Supreme Court did say that when mens rea requirements are not there, that they should be inferred. Secondly, I'd like to make it crystal clear that this piece of the evidence about the Supreme Court is not talking about one case. As it says, quote, "We have repeatedly held that the mere omission from a criminal intent of any mention of criminal enactment of any mention of criminal intent should not be read as dispensing with it. If the Supreme Court has repeatedly stated this, then it is not simply regards into one case." Additionally, I'd like to give you an example of some more cases that the Supreme Court has stated this on. This is from Reagan Gatlin from 2015, and it gives the example here of Morizet versus United States, Lipretta versus United States, and Posters and Things versus United States. All of these, the Supreme Court stated that mens rea requirements should be inferred. It's for these reasons that mens rea requirements are applied and that there is no problem, that I urge you to vote negative. Thank you.
My timer. All right. In this first affirmative rebuttal, I'm going to be going down the flow and responding to the two last speeches brought up by the negative team. I'm going to go ahead and start with Sarah's speech. Now, her first point was that the bill is in Congress. However, whenever my partner asked her in cross-examination where this bill currently was, she wasn't actually sure. And after Congress adjourned, this bill was still pending, therefore it died, and it has to be re-presented into Congress next session. So we can see that it died, it did not pass, and it has no intention of passing anytime soon until it is represented in Congress next session. Moving on, her second point was that it's currently applied. However, both of the negative speakers have agreed that only in 33% does a mens rea requirement currently exist. So it's not being currently applied in 67% of nonviolent crimes. 3, she said that there are different levels of mens rea. Now, I'm going to respond to that and her point about how we have a vague policy. I'm going to group those two arguments. Now, my partner and I have brought up several advocates, including Supreme Court justices, Heritage Foundation studies, including some other sources, talking about how this needs to be implemented into the system because innocent individuals like you and me are at risk of being unjustly convicted and punished. Now, we have advocates that are siding with the affirmative team. The negative team said that the Supreme Court is siding with them. However, they were not able to give you any specifics of the cases that they referenced that were heard in the Supreme Court. Moving on to Veronica's speech, she said that there is no current problem. However, again, they agreed that within statute, 67% of laws do not have a mens rea requirement. And because both the negative and the affirmative team can agree that due process is a right under the Constitution, we can see that innocent people are being affected by the lack of intent. Moving on to Veronica's next point, she said that we do not have sufficient examples and we are drawing an assumption. Now I'm going to group both of these. My partner and I are not drawing an assumption. We have given you personal examples. We have given you a study of empirics from the Heritage Foundation and the National Association of Criminal Defense Lawyers. We have given you Supreme Court justices' quotes as well as attorney generals.
The negative team is not responding directly to these sources and what they actually have to say. These advocates are siding with the affirmative team, as we have continued to show and will continue to show throughout today's debate round. Next, Veronica said that mens rea is inferred, and her final point was that the Supreme Court infers and says that we do need mens rea. Now, we shouldn't leave it up to the judge to decide if they're going to give you due process or not. This is a right that you have under the Constitution, and right now the Constitution is being violated. It is the negative team's contention that we leave this huge gash in the current system and wait until it becomes so serious that it is beyond repair. The affirmative team wants to stop this before it becomes an even bigger problem than it already is. As my partner illustrated with the example of internal bleeding, you can't see the problem on the outside, but internally you are completely being destroyed. And that's what's happening in the federal court system. The system is being destroyed from the inside out, and we need to solve this before it goes too far and we aren't able to solve the problem. We brought up personal examples of George Norris and Mr. Martin, and we can bring up more personal examples, but that will take a very long time. You see, there is a clear and present danger in the current system, and my partner and I seek to solve this. Innocent people should never serve years of jail time and be on probation or give thousands of dollars of fines for laws that they had no idea were even within statute. This is an injustice, and this is something that needs to be solved in the current system. The Constitution needs to be upheld and due process needs to be achieved. The negative team talked about how Supreme Court justices and other courts have the rule of lenity. However, my response to this is why leave it to chance? Why leave it to chance? Given the judicial rule of lenity, some may question whether Congress needs to create an interpretive rule for the mens rea in federal criminal law. They may prefer to leave it to the federal courts to decide within statutes. But again, we can't leave it up to these courts to decide whether or not your rights are going to be upheld today and maybe not tomorrow. It is for all these reasons that I ask you to affirm the resolution and cast a ballot for justice. Thank you so much.
How much negative prep time do we need? 1 minute. Now, the affirmative team has contended that the negative team is acting as if we cannot see the symptoms of internal bleeding and we're just letting this system crumble. But I mean, there are several flaws in this analogy. First of all, there are external symptoms to even internal bleeding, and we have effectively, in the status quo, diagnosed the symptoms already and treated it. And there's no reason for reform. My first voting issue, or one of the reasons that you should vote negative, is that there's no proven injustice. No proven injustice. And I will effectively respond to all of them when I AR under this voting issue. The affirmative team has brought up numbers about 67% of laws, and that all their advocates say that 67% of laws do not have adequate mens rea, and they're saying that this applies to cases. My response to this is that these 67% of cases apply under these lack of mens rea law, but that does not mean that the courts are not inferring that mens rea requirements still stand. There's no evidence that they are not inferring that this is the case. Secondly, that is because of the Supreme Court's precedence applies not only to this Alonis versus United States, but to all other cases. And we've seen that this is the case since they have repeatedly held this to be so, that a criminal act or a wrongful act must be conscious in order to be criminal, and they've repeatedly held that. And for that reason, there is simply no reason, we have no evidence and no reason to believe that there is injustice in this system, because the Supreme Court is already effectively treating this through a default mens rea by the Supreme Court precedents. Next, or actually first, she said that the bill in Congress did not pass, and so that my point doesn't stand. My response to this is that is exactly my point. That is exactly my point. The bill did not pass because Congress found it unnecessary. Congress found it unnecessary. They brought this bill that would require a critique to the mens rea of legislation, and Congress said, no, we don't need to pass this because it's already being inferred in the court system, and there's no reason and no harm for us, no result of injustice for us to actually have to pass this bill. The impact of this is that due process is not violated. Due process is not violated. We have seen a Supreme Court precedent. We've seen that Congress agrees that this is effective and did not need to pass a bill. And there's no harm, no injustice, and no proof that we actually need to change. My second voting issue is the impact of this, is that the affirmative team has failed to prove a problem. They failed to present a reason for us to change. And this is one of the affirmatives that they must uphold to warrant an affirmative ballot. And since they do not, the only box that you can effectively check is the negative ballot. My third voting issue is that we have no reason to vote affirmative. The status quo is already taking care of the system. We've already treated the symptoms. We've already treated and cured the system with our default inferred mens rea requirements in this court system, such that Congress found no reason to change it, and therefore the negative contends that there is no reason to change it because the status quo is already fixing the problem. For all these reasons, I strongly urge a negative ballot at the end of today's debate round. It's been a pleasure speaking for you. Thank you.
All my judges ready? Timer. In the last speech of this debate round, I'll be crystallizing the round down into 3 important voting issues, showing you why an affirmative ballot is still warranted, and showing you why none of the negative team's arguments stand at the end of today's debate round. Let's first respond to Sarah's last speech. Now, first of all, she talked about how there was no proven injustice. Now, I actually have 4 responses underneath this. My first response are examples. Examples. And you recall back to my last speech, we talked about 2 proven examples where we can see that there was a clear violation of justice in the status quo. My second response is 67% lack. 67% lack. This is a piece of evidence that both teams have contended to be true at the end of today's debate round. There is, in fact, a 67% lack of mens rea requirements in the status quo. And this is the example of an unjust system. My third response is system unjust. System unjust. And we've quantified this with both experts and evidence throughout today's debate round, not simply speculation, but they've shown you that this is, in fact, a proven fact. My fourth response is impossible standard. Impossible standard. Now, here's exactly what I mean by that. With the negative team asking us to show them the exact amount of times that someone's been convicted wrongly underneath criminal statute is an impossible burden to prove. Unfortunately, there's not someone counting every single time someone's wrongfully convicted, and then, because first of all, that's subjective, but then deciding whether or not that was decided because of a lack of mens rea or just because of the judge's discretion. So this is an impossible standard to hold the affirmative team to. Now, what we can do is give you the study that does talk about 67% lack in the status quo, and all the experts that say that mens rea is in fact vital and needed to provide for a constitutional system. Next, you talked about precedents, and I think there's been a little bit of misunderstanding on what exactly this means. My response only applies to the same case. Only applies to the same case. And the way that this works at the Supreme Court is that if they make a decision with a case related to certain details, that precedent only applies when a case with similar or identical details is brought back up so the lower courts can apply it. Now, when John Roberts said this, he didn't mean that the words mens rea and nonviolent crime are never anywhere found in that statement. Chief Justice John Roberts wasn't saying that this should be applied, mens rea should be applied to every single nonviolent crime. What he was saying was that wrongdoing should be, the punishment should fit the crime essentially, which we absolutely agree with. And unfortunately, that's not codified into law, which is what the affirmative team seeks to do today. Next, you talked about how Congress found it unnecessary. My response, this was actually not her initial point. This was not her initial point. Now, if you'll recall, her argument talking about Congress and the bill going through is that this was already solving the problem. Then her last speech talking about how Congress found it unnecessary. That wasn't actually her initial argument. She was talking about how this bill was going to solve the problem. Unfortunately, as my partner talked about, it died in the Committee on the Judiciary, and so therefore cannot reform the system. My second response, though, was no evidence to suggest Congress reasoning. No evidence to suggest Congress reasoning. It was basically the speculation of the negative speaker that Congress dispensed with this bill because they felt the justice system was efficient at upholding constitutional rights for all citizens with mens rea, but that was nowhere introduced into the round. It was simply speculation on the negative team's part. My third and last response is committee confirming the affirmative team. Committee confirming the affirmative team. Now, what I mean by this is there's actually a committee on overcriminalization that was put together. In fact, I read some evidence from that, Dr. John Baker, talking about how these crimes need mens rea. There's actually a committee right now in Congress that's put together to study these laws and make sure that they're not enacting ones that are harmful. This actually goes directly against what the negative team was saying, that Congress believes we're being effective. It's actually quite the contrary. In fact, we have a committee to study whether or not these laws are actually effective, and we've come to the conclusion that they are not. Next, let's go into my voting issues. My first voting issue is experts agree with the affirmative team. The experts agree with the affirmative team. Now, what the negative team has done today is provided evidence and read statements, but none of those actually directly apply to the case. Either the evidence that they have read is outdated in the case of the bill, or it doesn't actually apply to nonviolent criminal reform, which is what we seek to do today. On the other hand, we've given you Justice Holmes talked about the illustration and the importance of mens rea with the dog being tripped over and being kicked. We looked at the Heritage Foundation empirics. We talked about the National Association of Criminal Defense Lawyers. We talked about former Attorney General Larry D. Thompson. Lastly, we talked about Dr. John Baker's committee and testimony before overcriminalization in Congress. My second voting issue is status quo. The status quo, and I mean this in two ways. The first way that I mean status quo is the 67% lack. The 67% lack, which leads to the second way that I mean the status quo, and that is unconstitutional justice. Unconstitutional justice system. The problem is that intent is not enforced. And the negative team has come up here and said that this isn't needed, that we need to show specific examples, but repetition is not refutation. We've seen that the evidence is overwhelmingly sided with the affirmative team and has shown a need for mens rea in the status quo. That's what we seek to solve today. They talked about our burdens, that we need to show a harm. Our harm was the lack, 67% lack. The way that we solve that plan is to enact to solve for that lack. We have fully met our burdens, and we've shown advantages in the form of evidence and in the form of examples. Our last voting issue is efficient standard. Efficient standard. Both teams have agreed that the standard of mens rea does work in the status quo, that it's not complicated, and that it does enforce justice. Where we're different is whether or not it's significant and whether or not it solves, which we have proven throughout evidence and throughout this debate round. Thank you all so much. I really appreciate you being here today.
Second place team policy goes to Veronica Maska and Sarah Stokes.